Over the years, we've looked at different methodologies, researched other people's techniques, tried our own, and had our members give us feedback on various things. One thing we found is that there's a key concept people need to understand to deal with their legal cases. You might think your matter is about a child support case, a DUI, a mortgage, a criminal matter, or something similar. The reality is that it's all commerce, all business, and it's all about trusts. Today, we're going to talk about expressing the trust, why that's essential once you understand it, and then show you a document we've come across. We think this document could easily replace most of the status documents and similar tools that are out there. I'm going to go through a lot of terminology, but I want you to grasp the concept of why everything is a trust when it comes to courts and how you can use that knowledge to settle accounts rather than fight these cases. Why equity and expressing the trust is essential to winning. We have to look up some definitions as we go. For instance, an infant is a decedent of an estate until you declare otherwise. The courts presume you're coming in as an infant because you brought an attorney. You need someone else to represent you because you're not capable of managing your own affairs. Plus, you're not making your claim for the proper position in the court, you're coming in entirely the wrong way. You'll see when you read this contract. Members will get to see the whole version, we're just glancing over a little bit here, but you'll see how powerful this is. It's indisputable. Once we present this to them, it forms a trust that makes them liable. I love running under my own contract rather than trying to fight theirs. According to IRS Manual 21.7.13.3.2.2, an infant is a decedent of an estate or grantor. Wait, you thought that was just a baby? No, an owner or truster of a trust, guardianship, receivership, or custodianship that is yet to receive a Social Security number. Let me ask you, is it your estate that has a Social Security number, or do you have one? Regardless, the infant is the estate, that's what this is essentially saying. If you don't believe that, just read on. The more you study, the more you'll see that's how things are structured. You are the infant. You're being treated as the infant, and yet you're not making your proper claim to things. We also know there's a valuable Social Security account accumulating for us. It's worth more than you can possibly imagine. But we can't just go in there and cash it in, that's not our goal. We're just there to use it to settle our matters as we go through life. That's the basic concept people are missing. That's all it is. In 1933, the country went bankrupt. They took away all the money but had to give us a remedy by holding everything in reserve and effectively putting these estates together. Yet, we don't know how to operate them. Once you learn how to operate them, you gain a great deal of commodity and commercial power. The journey begins. Once the infant receives a Social Security number, it begins the journey as federal government property. You didn't know that, did you? A federal employee/taxpayer. Some call it the straw man. You may have heard that term, with the father and the mother as fiduciaries to protect the state property via the newly created statutory trust estate for the infant. That birth certificate that was created? It created an estate, and it's being held in trust. It's identified by a stock certificate called the Certificate of Live Birth. Look at it, it's a stock certificate, folks. That estate is subject to tax reporting and taxed on income based on the self-confession that it's income to the individual. This is done by requiring you to self-report on a 1040A or 1040 form, which is a contract or affidavit sworn to be correct and complete under penalty of perjury. Folks, this is how you get tied into the system. But don't worry, it's just a contract. We just need to create a new trust to correct the position. What happens at age 18? Once the child turns 18, they assume the title of co-trustee and co-beneficiary. Remember, a trustee in any relationship is liable. You go through life being liable, don't you? But you also forget to claim that you're a beneficiary? You need to learn how to do that, and you're about to learn. Take good notes. You've got to claim that position. The father, as described below, must claim the title of third-party intervener for the holder of the person occupying the office of the general executor of the infant's estate. Otherwise, they face consequences of abandonment in the administration of the estate. What that means is that you've got to step up, Say you understand what's going on, know how to run it, and execute it yourself. All you have to do is claim to be a beneficial owner. That's all this really equates to. Courts and judges know this, and they rightfully step in as administrators under an undisclosed constructive trust for the minor child, which is essentially you. Why minors are treated as incompetent. Legally, if the father and mother, or you as an adult, act as incompetent in administering the child's estate, you are treated as a minor. This legal term is important to understand because it contrasts with being of the age of majority. The term age of majority signifies that you've learned to step up and take your proper position. By not stepping up, declaring the trust, getting an attorney, and entering a plea, you place yourself as being incompetent, a ward to the court. You're not acting as a beneficiary and are instead treated as someone who is acting like a minor. These terms matter, ladies and gentlemen. If you abandon your rightful position as the primary beneficial interest title holder, you essentially lose your claim to everything. For example, you might feel entitled to a car or property, but if you don't formally claim it, the court can grab it as unclaimed property. It's like abandoning property at sea. After a certain period, someone else comes in to claim it. The court process explained. When you walk into court, you essentially cross the docket, carrying a vessel of documents with numbers on them, and dock it in the court. This is a transaction. Until you claim your title and manage it properly, the court assumes administrative control over you and your estate. Consider the following scenario. The state-issued marriage license, along with the state-issued birth certificate for a new child, effectively pledges, gifts, orphans, and abandons the minor child. The child is left adrift on the sea of commerce. The child's future labor and estate now belong to the United States, as the government takes responsibility for them until the individual steps up to take control. Until you exercise this process and take control, you will be treated as an orphan minor child and a ward of the state. Becoming the beneficial title holder. When you fail to claim your securities, you become part of the collective res. The res is the property or thing put into a trust to give it value. In this case, it's for the full faith and credit of the United States, which itself operates as a trust. By doing nothing, you voluntarily become the surety for all debts, essentially underwriting the debts of the United States and its officials. By default, your position is treated as abandoned, and your title becomes available for others to claim. This is why it's critical to voluntarily step up, claim your title, and express the trust relationship. The importance of expressing the trust. To change your position, you must 1. Recognize that you are the beneficiary of the trust. 2. Express that relationship both in writing and in court. 3. Avoid acting in a way that implies incompetence or abandonment. The courts and judges are aware of this, which is why they often assume the role of administrator or trustee under an undisclosed constructive trust. Their assumption is based on your failure to claim and express your trust relationship. What is a trust? A trust must have 3 key elements. 1. A trustee, the person managing and controlling the trust on behalf of another. 2. A beneficiary, the person who benefits from the trust. 3. A grantor, the person who establishes the trust. In court, when you give up your name or fail to claim your title, you're effectively giving up all your property to the court. They then seize control of your birth estate and place a bond on it. This financial framework means that courts act as administrative venues. If you don't step up and assert your proper position, they will default to treating you as a minor or ward of the state. Minor versus age of majority. In the legal world, the term minor doesn't only refer to someone under the age of 18. It can also refer to an adult who has not yet taken control of their securities or trust account. For example, your Social Security account is often referred to as a minor account because you haven't exercised control over it. When you step up, express the trust, and claim your position, you are effectively transitioning to the age of majority. This changes how courts and other institutions treat you. Steps to express the trust. Here's how you can express the trust effectively. 1. Declare your position, state clearly in writing and in court that you are the beneficial equitable title holder. 2. Submit supporting documents, present documentation, such as your birth certificate, to substantiate your claim. 3. Use proper terminology. Understand terms like res, beneficiary, trustee, and age of majority. These will help you navigate the legal process confidently. 4. Avoid volunteering as surety. Refuse to take on liability by acting as the trustee. Insist on your role as the beneficiary. By doing this, you place the burden back on the court to fulfill its fiduciary duty. Once the court recognizes your position, they are required to administer the trust accordingly. The power of written documentation. When presenting your case in court, it's crucial to have your documentation prepared. This should include a declaration of your position as the beneficial equitable titleholder, a bill of complaint in equity outlining your claims, a demand for the court to fulfill its fiduciary duties as trustee. Never submit a document you cannot confidently explain in court. Be prepared to back up your claims with evidence and law. Memorizing your script. When entering the courtroom, you might say, I am here in special appearance as the beneficial equitable titleholder on matters involving the named trust in this matter. I also require the court to take notice of my bill of complaint in equity and recognize that I appear only in the capacity of one who is at the age of majority. This process ensures that you are no longer treated as a minor or ward of the state. By stepping into your rightful position, you take control of your estate and direct the court to act accordingly. Avoiding confusion and staying on point. If the court tries to sidetrack or ignore your declaration, remain calm and assertive. Simply state, I do not consent to proceed until the court acknowledges my capacity as the beneficial equitable titleholder. You may need to repeat this 3 times, as the court might attempt to dismiss or distract from your claim. Always bring extra copies of your documents to provide if needed and maintain your focus on the main issue, your position in the express trust. Transitioning from straw man to beneficiary. Many people use the term straw man, which has been overused and misunderstood. It essentially refers to the legal entity or persona the court assumes you represent. When you express the trust, you shift the court's perception. You are no longer seen as the straw man or defendant but instead as the principal beneficiary with equitable interests. This changes the jurisdiction and the court's obligations toward you. It forces them to recognize your position and fulfill their fiduciary duties. The Bill of Complaint in Equity. A Bill of Complaint in Equity is a key document in this process. It serves as your declaration and demand for the court to act within the framework of equity law. The introduction to this document might state, John Henry Doe, a natural living being of majority status, conducting the style and condition of the principal and beneficial equitable titleholder, does hereby tender this claim and demand for relief. This document also includes claims of how the court or opposing party has violated trust principles, such as 1. Failing to recognize your position as beneficiary. 2. Acting in an administrative capacity without your consent. 3. Misappropriating or bonding your estate without just cause. When properly written and submitted, this document shifts the court's focus to equity jurisdiction and establishes the necessary relationship of trust. Establishing exclusive jurisdiction. Equity jurisdiction is critical because it involves trusts, estates, and fiduciary relationships. By invoking this jurisdiction, you redirect the proceedings away from criminal or administrative law, focusing instead on trust law. For example, you might state, this matter directly involves the property, estate, and securities of an infant minor under equitable law. Therefore, this court must act under exclusive jurisdiction in equity. The inclusion of legal references, such as Presidential Proclamation 2038 and 2039, supports your claim that this jurisdiction has been in effect since 1933. By citing these, you remind the court of its responsibilities under trust and equity law. Demanding accountability and transparency. You have the right to demand full transparency of the court's financial transactions related to your case. This includes 1. A full accounting of all receivables and payables tied to your estate. 2. An affidavit verifying these transactions. 3. Proof of how the court has administered the trust to date. Such demands place the burden of proof on the court, ensuring they act within their fiduciary capacity. The elements of a trust. To reinforce your position, you can outline the elements of a trust. 1. The grantor, the entity that establishes the trust, often the state or federal government in the context of birth certificates and social security accounts. 2. The trustee, the party responsible for managing the trust. In court proceedings, this often defaults to the court or administrative body unless you assert otherwise. 3. The beneficiary, you, the rightful holder of the equitable interest. By clearly identifying these roles and presenting yourself as the beneficiary, you ensure that the trust operates in your favor rather than against you. Demanding relief in equity. Your bill of complaint in equity should conclude with specific demands, such as 1. The immediate settlement of all accounts tied to your estate. 2. Compensation for any damages caused by the misadministration of the trust. 3. A declaration affirming your position as the beneficiary and equitable title holder. By framing your demands in equity, you ensure that the court is compelled to act within its legal limits and fiduciary obligations. Understanding equity law in depth. Equity law operates on the principle that courts must act in good conscience to protect the rights of beneficiaries. This principle is supported by maxims such as: equity will not suffer a wrong without a remedy. He who seeks equity must do equity. When you assert your position properly, the court is obligated to administer the trust in a manner that benefits you rather than the state or other parties. Memorandum of Law. To support your claims, attach a memorandum of law to your filings. This document provides the legal foundation for your position, citing statutes, case law, and historical precedents. For example, 1. The definition of a minor as per legal codes, e.g., 31 CFR 363.3. 2. The responsibilities of trustees under trust law. 3. The rights of beneficiaries under equity jurisdiction. This memorandum strengthens your case and ensures the court cannot dismiss your claims as baseless. Final steps in court. When presenting your case, ensure you remain calm and professional. State clearly: I am here in special appearance as the beneficial equitable title holder on matters involving the trust. I direct the court to fulfill its fiduciary duty and settle all accounts as outlined in my bill of complaint in equity. If the court attempts to proceed without acknowledging your position, repeat your demand. I do not consent to proceed until the court recognizes my capacity and acts accordingly. Persistence is key. By staying focused on your position and the principles of trust and equity law, you compel the court to act within its legal limits.